Denzel Washington stood before the Supreme Court of the United States, his tailored Navy suit contrasting sharply with the imposing marble columns behind him. Just moments earlier, Justice Amy Coney Barrett had looked directly at the Hollywood legend and said, "Mr. Washington, I'm not sure someone from the entertainment industry can adequately address constitutional questions of this magnitude." The packed courtroom fell silent. Legal correspondents froze pens hovering above notepads. This unprecedented dismissal of one of America's most respected actors had created an electric tension that permeated the highest court in the land. What happened in the next 3 minutes left the entire chamber speechless and may forever change how the legal establishment views expertise from outside traditional pathways with remarkable composure. Washington was about to deliver a response that would stun Justice Barrett and transform the dynamics of this historic case. Before we dive into this remarkable confrontation between a Supreme Court justice and one of Hollywood's most distinguished actors, please take a moment to like this video and subscribe to our channel. You'll never miss our exclusive coverage of the fascinating intersections between America's cultural icons and its most powerful institutions to understand the significance of this extraordinary confrontation. We must first examine who these two formidable individuals are and why their unexpected clash carries such profound implications. Amy Coney Barrett, appointed to the Supreme Court in 2020, quickly established herself as one of the court's most formidable constitutional minds. A former Notre Dame law professor with a reputation for brilliant textual analysis, Barrett's incisive questioning during oral arguments has become legendary in legal circles. Her rigorous originalist approach to constitutional interpretation has made her a powerful voice on the nation's highest court, particularly in cases involving First Amendment protections. With her meticulous preparation and unwavering confidence, Barrett has rarely encountered an argument she couldn't dissect or a legal position she couldn't challenge effectively. Denzel Washington, by contrast, represents an entirely different kind of American excellence. His distinguished acting career spans 4 decades, with 2 Academy Awards and countless other accolades, establishing him as one of Hollywood's most respected figures. Less known to the public, however, is Washington's long-standing interest in constitutional law and civil rights. The son of a Pentecostal minister and a beauty shop owner, Washington had originally considered law as a career before pursuing acting at Fordham University. Throughout his life, he has maintained a passionate engagement with legal questions, particularly those affecting underrepresented communities. The case that brought these two remarkable individuals into confrontation involved a complex First Amendment question around religious expression in public education, specifically whether a high school coach's post-game prayers on the field constituted protected private speech or impermissible government endorsement of religion. Washington had been invited to submit an amicus brief by the American Civil Liberties Union after making substantial donations to legal education programs for underprivileged youth for Barrett. This case represented an opportunity to further refine the court's approach to religious expression. Case is an area where she had developed significant jurisprudence for Washington. It was a chance to leverage his influence for a cause he deeply believed in, ensuring that constitutional protections were accessible to all Americans, regardless of background. The stakes extended far beyond the immediate case at issue, was whether voices from outside the traditional legal establishment could meaningfully contribute to constitutional discourse at its highest level. Barrett's challenge to Washington's credentials wasn't merely about one actor's qualifications. It implicitly questioned whether the rarefied air of constitutional interpretation should remain exclusively the domain of lifelong legal scholars and practitioners. As Washington prepared to respond to Barrett's dismissive comment, observers from across the political spectrum recognized that this confrontation could potentially reshape perceptions of expertise, authority, and legitimacy in America's legal discourse. The tension had been building throughout the morning session as the Supreme Court heard arguments in the case of Kennedy versus Breton School District. The justices had already questioned the attorneys representing both sides when Chief Justice Roberts acknowledged the unusual step of allowing brief comments from Denzel Washington, whose amicus brief had drawn significant attention. Washington approached the lectern with the same dignified presence that had captivated movie audiences for decades. He began by thanking the court for the opportunity to speak his resonant voice, filling the chamber with measured authority. Your Honors, the Constitution's protection of religious expression speaks not just to legal scholars, but to every American citizen. As someone who, Justice Barrett interrupted her tone. Pointed Mr. Washington. While we appreciate your interest in this case, I'm curious what qualifies an actor to advise the Supreme Court on constitutional interpretation. There are complex precedents at play here that require years of legal study. Washington paused, maintaining perfect composure. Justice Barrett. I'm appearing today not merely as an actor, but as a concerned citizen who has studied this issue extensively. Barrett pressed further, her questioning becoming more challenging, but without formal legal training. How can you meaningfully engage with cases like Lemon versus Kurtzman or Santa Fe Independent School District versus do these precedents require sophisticated legal analysis? The audience tensed. Several justices appeared uncomfortable with Barrett's unusual directness toward an amicus participant justice. Stower shifted in her seat, while Justice Kagan glanced at her notes. Washington began citing specific aspects of his brief, but Barrett interrupted again. Mr. Washington, the entertainment world may value emotional appeals, but this court deals in constitutional principles and legal reasoning. I've reviewed your brief, and while eloquent, it seems to lack the jurist credential foundation. This case requires the dismissal was striking in its directness. Court observers later described it as an unprecedented public challenge to an amicus. Participants' very right to be heard. Washington stood still at the lectern, his expression revealing nothing, as Barrett continued. Perhaps you could clarify which legal methodology you're employing in your analysis. Are you approaching this from an originalist perspective, a living constitutionalist view? Or is this simply a policy preference dressed in constitutional language? The question hung in the air, its implied criticism unmistakable. Attorney General Elizabeth Prelogar, seated in the front row, looked visibly concerned at this departure from the court's typically respectful treatment of participants. Washington took a measured breath. Justice Thomas, known for his silence during oral arguments, unexpectedly spoke up. Justice Barrett. Perhaps we should allow Mr. Washington to respond fully. Barrett nodded slightly, gesturing for Washington to proceed. The courtroom fell completely silent as all eyes turned to the actor, wondering how he would respond to this direct challenge from one of the court's most formidable legal minds. Washington adjusted his papers calmly. The tension in the room building with each passing second. Court artists frantically sketched the scene as the Hollywood icon prepared to respond to what many were already describing as an attempt to intellectually dismiss him from the conversation. What happened next would be described by legal observers as a masterclass in composed intellectual authority that no one in the Supreme Court had anticipated. Denzel Washington straightened his shoulders, his demeanor calm yet resolute when he spoke. His voice carried the same measured authority that had commanded movie screens for decades, but now infused with precise legal clarity that startled the chamber. Thank you. Justice Thomas Washington began. Justice Barrett. I appreciate your question about my qualifications and methodology. He paused briefly, establishing full command of the moment. While I lack formal legal credentials, I would respectfully suggest that constitutional interpretation isn't exclusively the domain of those with law degrees. Washington then reached into his briefcase and removed a well-worn copy of the Constitution, its pages marked with dozens of tabs. For the past 15 years, I have funded a constitutional literacy program that has educated over 20,000 underprivileged youth about their constitutional rights. During this time, I've had the privilege of studying with several constitutional scholars, including Professor Akhil Rita Mahar at Yale, and your former colleague at Notre Dame, Professor Richard Garnett. Barrett's expression remained neutral, but those seated nearby noticed her posture shift slightly. As for my methodology, Washington continued, I approach this case from what I believe is consistent with your own jurist credential philosophy. Justice Barrett, a careful textual analysis informed by original public meaning. The first murmurs swept through the courtroom. Washington was directly engaging Barrett on her own methodological terrain. If I may, he continued, the specific question before the court involves whether Coach Kennedy's prayers constitute private speech protected by the Free Exercise Clause or government speech restricted by the Establishment Clause. The pivotal Supreme Court precedent here isn't actually Lemon versus Kurtzman, which has been increasingly marginalized by this court, but rather Kennedy versus Breton School District itself, where this court emphasized that respect for religious expressions is indispensable to life in a free and diverse republic. Washington had quoted perfectly from the court's own recent decision, directly addressing Barrett's implication that he was unfamiliar with relevant precedent. Several justices exchanged glances. Moreover, Washington continued, if we examine the historical practices and understandings at the time of the First Amendment's adoption, as Justice Thomas eloquently outlined in his concurrence in American Legion versus American Humanist Association, we find that public religious expression was not understood as creating an established church of the kind the framers sought to prohibit. Washington then proceeded to cite 5 additional Supreme Court cases, with precise page numbers and key quotes, all without consulting any notes. The gallery, filled with seasoned Supreme Court reporters, remained absolutely silent, as Washington systematically demonstrated a command of constitutional jurisprudence that rivaled that of experienced Supreme Court advocates. Furthermore, Washington added, I'm particularly compelled by James Madison's memorial and remonstrance against religious assessments, where he articulated that religious duty is precedent, both in order of time and in degree of obligation to the claims of civil society. This understanding illuminates why the court should be particularly cautious about limiting individual religious expression, even for government employees when acting in a personal capacity. Barrett, who had begun taking notes, looked up as Washington directly addressed her earlier criticism. Justice Barrett, you asked about my jurisprudential approach, like your own scholarship on constitutional interpretation, which I've studied with great interest. Particularly, your article on originalism and stare decisis in the Notre Dame Law Review. I believe we must begin with the text, understand it in its historical context, and apply it faithfully. Regardless of policy preferences, the courtroom remained stunned. Washington had not only demonstrated an extraordinary command of constitutional law, but had specifically engaged with Barrett's own legal scholarship. Justice Kagan, known for her strategic questioning, appeared impressed, while Justice Alito nodded slightly. Washington concluded with quiet authority. I stand before this court not because of my accomplishments in film, but as an American citizen deeply committed to constitutional principles. I've spent thousands of hours studying these issues, not for professional advancement, but out of profound respect for the document that guarantees our freedoms. Whatever my limitations, I believe there is value in hearing from citizens who engage seriously with constitutional questions, particularly when they represent perspectives from communities historically excluded from these conversations. As Washington finished, The courtroom remained absolutely silent. Justice Barrett, renowned for her quick responses and incisive follow-ups, appeared momentarily at a loss for words. Finally, she spoke. Her tone noticeably changed. "Thank you, Mr. Washington. Your preparation is evident. I appreciate your thoughtful engagement with the constitutional questions at hand. It was as close to a public acknowledgement of misjudgment as Supreme Court observers could remember." Hearing several justices, including Chief Justice Roberts, nodded in agreement. Washington nodded respectfully and returned to his seat, leaving behind a courtroom still processing what they had just witnessed, a Hollywood actor demonstrating constitutional mastery that had earned the visible respect of the Supreme Court's most formidable originalist. The repercussions of the Washington-Barrett exchange reverberated far beyond the marble halls of the Supreme Court. As the session concluded and attendees filed out of the courtroom, the unprecedented confrontation dominated every conversation. Veteran Supreme Court reporters who had witnessed thousands of oral arguments described it as an extraordinary moment in the court's modern history. Within hours, video clips of the exchange spread across social media and news outlets. The AR number TID Denzel Knows the Law began trending nationwide, with legal scholars, celebrities, and ordinary citizens sharing their reactions. Constitutional law professors found their students suddenly engaged with complex legal doctrines, as Washington's eloquent defense of textual interpretation made abstract constitutional concepts accessible to millions inside the Supreme Court building. The atmosphere had palpably shifted. Court staffers reported that following the session, Justice Thomas approached Washington and engaged in an animated 5-minute conversation that concluded with the typically reserved justice smiling broadly. Justice Kagan was overheard telling a clear that Washington's analysis of the Establishment Clause could have come from a seasoned constitutional litigator. Perhaps most significantly, Justice Barrett herself requested a meeting with Washington before he left the building. According to sources close to the court, the two spoke privately for nearly 15 minutes in the court's ceremonial East Conference Room, while the content of their conversation remained private. Those who saw Barrett emerge described her as thoughtful and reflective. The following day, as the justices gathered for their private conference to discuss the case, the impact of Washington's presentation was immediately apparent. Sources familiar with the court's deliberations revealed full context to their consideration of the case. Chief Justice Roberts reportedly noted that the exchange demonstrated how the court benefits from hearing diverse voices, even from outside traditional legal pathways. Legal analysts across networks provided extensive coverage of the confrontation and its implications on CNN. A constitutional law professor from Harvard observed, "What we witnessed was more than a Hollywood star holding his own with a Supreme Court justice." It was a powerful reminder that constitutional interpretation at its core should be accessible to all citizens, not just legal elites. The Washington Post ran a front-page article headlined, "From Screen to Supreme Court, Washington Challenges Legal Orthodoxy," which explored the actor's long-standing but little-known engagement with constitutional law. The piece revealed that Washington had been quietly funding legal education programs in underserved communities for over a decade and had personally contributed to scholarship funds for minority law students at Howard University, his son's alma mater. Fox News legal analyst Jonathan Turley commented, "Regardless of one's views on the specific case, Washington demonstrated that serious constitutional engagement can come from unexpected quarters." Justice Barrett, to her credit, appeared to recognize that by the end of the exchange within the broader legal community, the confrontation sparked intense discussion about who owns constitutional interpretation. Law schools reported a surge in applications from non-traditional candidates, with many citing Washington's Supreme Court appearance as inspiration. Georgetown Law School announced a new lecture series titled Citizens and the Constitution, with Washington invited as the inaugural speaker for Barrett. Personally, court observers noted subtle changes in her approach during subsequent oral arguments, while maintaining her characteristically sharp questioning. She appeared more receptive to perspectives from amicus participants, particularly those representing community organizations, rather than traditional legal institutions, during a case 2 weeks later involving voting rights. Barrett specifically invited input from a civil rights leader without formal legal training, asking about the practical implications of competing interpretations. Social media continued to amplify the significance of the exchange. A TikTok video of a young black pre-law student analyzing Washington's constitutional arguments garnered over 15 million views, with thousands of comments from young people newly interested in constitutional law. Washington's foundation reported receiving over $3 million in new donations to support constitutional literacy programs in the week following his Supreme Court appearance. Even Hollywood felt the impact. Scripts featuring legal themes saw renewed interest, with producers seeking greater authenticity in their portrayal of constitutional issues. Washington himself received offers to star in a limited series about the life of Thurgood Marshall, the Supreme Court's first black justice. The legal outcome of the case itself became almost secondary to the larger cultural moment when the court eventually ruled 6-3 in favor of protecting the coach's right to pray, with Barrett writing for the majority legal analysts. Noted several passages that seemed to echo Washington's arguments about the historical understanding of religious expression. More surprisingly, Barrett's opinion explicitly acknowledged the value of perspectives from those who experience constitutional protections in their daily lives, a phrase many interpreted as a direct reference to Washington's contribution. Washington's brief statement to the press after the ruling emphasized that the significance of his Supreme Court experience extended beyond the specific case. The Constitution belongs to all Americans. He said, "Not just those with law degrees. My hope is that more citizens will engage deeply with these fundamental principles that shape our lives and liberties." Perhaps the most lasting impact came 6 months later, when Chief Justice Roberts announced the formation of a new Supreme Court Advisory Committee on Public Engagement, dedicated to making the court's work more accessible to ordinary citizens. Among the 13 appointed members was Denzel Washington, the only non-lawyer invited to serve. Constitutional scholars began referring to the Washington-Barrett exchange as a pivotal moment in the court's modern history, not because it fundamentally changed constitutional doctrine, but because it challenged long-held assumptions about who can participate meaningfully in constitutional discourse. A professor at Columbia Law School observed, "In a single exchange, Washington demolished the artificial barrier between legal insiders and outsiders, showing that constitutional understanding can come from commitment and study, not just credentials." For Barrett, the confrontation appeared to prompt reflection on the nature of expertise and authority in a rare public lecture at Notre Dame Law School. 3 months later, she emphasized that constitutional principles must be accessible to all citizens if they are to endure, without mentioning Washington directly. She acknowledged that those of us immersed in legal doctrines sometimes lose sight of how these principles operate in the lives of ordinary Americans. The Washington-Barrett exchange ultimately transcended both politics and celebrity to raise profound questions about democratic engagement with foundational legal principles beyond scoring points for either liberal or conservative interpretations. It challenged the very notion that constitutional understanding requires specialized credentials rather than dedicated citizenship, as Barrett wrote in her Kennedy majority opinion. Quoting Washington's amicus brief without attribution, "The Constitution's guarantees are not reserved for those who interpret them professionally, but for all who live under their protection. This acknowledgement, perhaps more than any legal doctrine established in the case, may prove to be the exchange's most enduring legacy." The question now facing America's legal institutions is whether this moment represents a fleeting celebrity-driven anomaly or the beginning of a more inclusive approach to constitutional discourse. Will the doors Washington pushed open remain accessible to other voices from beyond traditional legal pathways? If you found this analysis enlightening, please like this video and subscribe to our channel for more in-depth coverage of the institutions and individuals shaping American life. Hit the notification bell to be alerted when we release our upcoming special report, Beyond the Bench: How Outsider Voices Are Reshaping Constitutional Understanding.